Right. Hello. Good evening to everyone who is joining us. We're just taking a couple of minutes to let everyone in as they join. We've got some good attendance today at 40 participants, and I'm sure we're going to have many more join. And I'm sure we're going to have many more questions than 40 on this webinar. We're just going to wait 2 more minutes. For those who have already joined, it would be fantastic to hear why you're here. What do you do? Are you a marketing company? Are you a startup? What type of startup are you? Are you an advisor? Are you legal? Are you tech? Please pop something in the chat box so we can learn more about you. This is not only an information session and not just a practical way for us in the tech and innovation space to engage on what the POPI Act is about, but always an amazing opportunity to come together as a community and get to know one another. So if there is something you'd like to share with the community, now's your time. Put it in the chat box. Please feel free to interact with each other. Our numbers are climbing, and we're not even watching the COVID count. So this is a really positive count to watch tonight. Dylan Burns, who is assisting us with the tech coordination tonight, he is letting everybody in. Just a reminder to please all stay on mute and please keep your videos off for the sake of the streaming going smoothly. We will have a session at the end where we can interact. So super to see where everyone is from. Right, we've got education consultants, we've got communication managers. Yes, everyone's tearing their hair out. What do we do with POPI? Daniel, also education sector from Stellenbosch, super. Right, another marketing and comms consultancy. Spatial edge, big data management. It's fantastic. Yeah, CTOs. I'd love to hear what the CTOs have to say about this. Yep, and all of us working in the digital social space, all wondering how and what we should be putting up on all our different channels. Right, for those of you who have just joined, we are just hanging in for a couple of minutes. We're at about 55 participants. If you've just joined, perhaps pop something in the chat box. Let us know who you are, what you do, where you're from, why you're here. Will be super. No, you don't want to know what CTOs think about. Yes, that is interesting, Joshua. Right, super. I think from a admissions point of view, I think we can get started. Right, I am going to kick off this session. And please, as we continue to do all the introductions, make sure that you are typing away in the chat box, introducing yourself, making notes of who's on this call. If you want to connect with people, please put your LinkedIn profile into the chat box. It makes it super easy for people to find you if you want to be found. And if you don't, please just listen in and enjoy the session. Right, my name is Caitlin Nash. I am the managing partner at a company called Loudhailer. We have a big, audacious mission and vision to raise the visibility of African innovation on the global stage. So we work with innovation programs and next-gen tech to build partnerships to gain commercial traction, investment, and really with hopes that all of us will play a role in job creation, generating investment into Africa, and very idealistically making the world a better place. So I think the tech space is filled with a lot of hopefuls and a lot of idealists, and at the same time polarized with many on the other end of the spectrum, keeping us real. Right, today we are here with the thanks to Silicon Cape, as well as the Stellenbosch Network. really a phenomenal opportunity to bring these two organizations together who work tirelessly to support and connect various tech-enabled businesses in the Western Cape to flourish. I think many of you will know that there is a very focused attempt to continue to build Cape Town and its surrounding areas as the tech region of Africa, and to connect with our various partners across Africa. So very exciting that we have such robust engagement tonight and participation. Tonight, we will be talking about the POPI Act, which came into effect on 1 July. And there's been so much debate on the various social channels that we thought perhaps we should have a conversation about this. So tonight we have brought on board, with the help of Silicon Cape and Stellenbosch Network, we have brought on board a senior associate from Cliff Decker Hofmeyer, who is a specialist in technology, media, and telecommunications, and that is Apandile. Hello, Apandile. Apandile is going to chat to us tonight about what does the law actually say, and what do we actually need to know about complying to this law. Then we're going to hear from Tian van Zyl, who is the digital analytics lead at Traffic Brand, also a local firm here. And he's going to unpack what businesses need to be doing with their social media and digital platforms to maintain POPI compliance. So let's talk about what the regulations say and then how we practically implement this and what we should prioritize. Right, the order of events for tonight on this webinar we'll have an introduction from Vusi Tembakwaya, who is the co-chairperson of Silicon Cape. Then I will let Hanley Brink introduce herself and introduce Stellenbosch Network as an organization. And then I'll hand over to Apandile and to Tian. There's going to be a lot of listening. Please chat away in the chat box. I will be taking note, and I'll be supported by Dylan Burns and Amara Daniels from the Loudhailer. And after we have heard everybody speak, we will open up Q&A for us to engage. When you ask a question, please be sure to just direct your question at a specific person. We will be taking notes and cluster that and save that towards the end. Right, but before we kick off and have some fun, we first have to talk about the rules. Right, for the benefit of others, please keep your video off. Please ask questions in the chat and we'll answer them at the end. And just a note, the session is being recorded and will be made available at the end of the event. Right, super. So just a reminder for those that have joined, please add in your LinkedIn profile if you want to be found. If you don't want to be found, please listen in and enjoy the conversation tonight. Right, that being said, I would very much like to ask Vusi to join us. And Vusi, please will you kick off about Silicon Cape? And you've recently joined. It's obviously very exciting for the Western Cape tech community to have you sharing your wisdom and your energy and your vocational connection with entrepreneurship in Africa. Super to have you here tonight.
Brilliant. Thanks, Kate. And good evening to everybody that's joined us on this webinar. First, let me just say that what an interesting time to be alive. What an interesting time to be South African. And what an interesting time to be entrepreneurs, or those of us who work in this ecosystem. In whatever role that you play, all of us, I think, seized with the challenge of making sure that we make the country better than it is, frankly. So a bit about Silicon Cape. Silicon Cape's been around since 2009, founded by my actually very good friend, Vinny. I was on the phone with him yesterday. And Justin Stanford. Both of them have a track record of building high-scale businesses. And at the time they were founding Silicon Cape, the challenge was around building an ecosystem that would ensure that entrepreneurs, innovators, and founders building businesses would land in a runway of opportunity. That was then. Since then, a lot's happened. The environment has changed a lot. Regulation has changed a fair bit. Some new laws have come in, others have come in and then have also been scrapped. As we speak, we at Silicon Cape, together with our partners at Loudhailer and several other partners, are seized with putting together a cohort of people who are working and deliberating around creating a startup act for South Africa. So one of the things I'd like to ask of everybody in this conversation is, if you've not been to, please go to the website, and I'm hoping the team will share it on the chat. and sign up as a signatory to support the work we're doing to build an ecosystem that is regulated and legislated through the Startup Act. Silicon Cape is a nonprofit ecosystem enabler. We work for tech-enabled startups. And at the onset, it was always really about the Border Cape region of South Africa. Since then, we've set our sights much, much broader. We've been talking about how do we become the spearheading movement that builds the stakeholder engagement platform across the entire continent for everybody that seeks to do the work that we do. Because in truth, what many other parts of the continent are yet to learn, we've actually long forgotten. So it's about how do we share knowledge, best practice, ideas around how do you build an ecosystem. And this word ecosystem is fundamental, because if you think about what it takes to do what we all do, it takes the village really to raise the child that is the startup. It's not only the capital that is provided by people like myself who run funds, but also it's the work that's done by universities who not only educate a lot of startup founders, but also in other parts of the world, as we see, help them actually incubate a lot of those businesses. It's work done by incubators whose role in the early stages of those businesses is fundamental. Work done by accelerators whose role in the growth phases of those businesses cannot be overstated. Work done by lawyers whose job in ensuring that the legal framework around which some of these startups have been built is strong, solid, and globally competitive. Because if we are to build a startup ecosystem that succeeds, we need not only local capital, but actually international capital as well. And so a legal fraternity that understands what regulation says what about which type of innovation, which territories compete with us, how, and how do you build a startup that can raise and attract global capital, but add value in the local ecosystem is fundamental for all of us. And across all of these, each and every single part of the ecosystem, these are corporates who might be part of supply chains, that some of these innovation startups can plug into. It's consumers who are early adopters to some of these technologies and products. The point here is that there is no player more important than any other. All of us are seized with creating an ecosystem that ensures that everybody succeeds. So that's the work of Silicon Cape. We really see ourselves as a part of and not apart from the entire ecosystem. We believe that our role is to facilitate, enable, engage, and inspire the ecosystem. And we, as I say, have a Pan-African perspective. This is why in our logo, we have the African continent connected by those three dots. We'd love to partner with those of you who are in this conversation that are looking for other ways for us to have discussions. We'd love to partner with those of you who want to engage and find out how do you become a member. And of course, we'd love to partner with those of you who would like to also understand what you can do to help us with the initiatives that are currently underway for the SA Startup Act. So that's a bit about us. That's a bit about Silicon Cape. And with those words, I'm going to hand over to the indomitable Caitlin Nash.
Thank you, Busi. It's so wonderful to have your voice in this ecosystem. And I really think it's for all of us to use this as an opportunity to reconnect, get behind the Startup Act, get involved, educate yourself, and let's push this thing forward, because it's not going to happen by an organization out there. It's going to happen by us doing something. So that being said, we have Hanley Brink from the Stellenbosch Network here. Hanley, it's phenomenal to have you here. You know, there's always so much going on in Stellenbosch from an academic, ideation, IP point of view, and great tech companies out there. I see many have joined us today. I think there's tremendous opportunity in bringing our Cape Town, Stellenbosch, wider Western Cape tech startups together. And as Busi said, we're sitting on a huge amount of knowledge, and there's this opportunity to springboard this information to hubs across the continent. But we'd love to hear about who is the Stellenbosch Network, what do you guys do? Please introduce yourself. Thanks, Hanny.
Thank you, Caitlin. Thanks so much for the opportunity. Absolutely no pressure to speak after Busi, who's so inspiring to everyone. But yes, thanks for the opportunity. As Caitlin mentioned, I'm Hanley Brink. I'm the Operations Director at Stellenbosch Network. Stellenbosch Network was initiated by the University of Stellenbosch, and we launched in November 2019. The founding members are the University, Department of Science and Innovation, Remgro, Capitec, Westgrow, the Municipality of Stellenbosch, Netbank, Intersect, WineTech, and Ranyaka, who's our social impact partner. Now, the vision of Stellenbosch Network is to facilitate and positioning the Stellenbosch region internationally as an inclusive and interconnected innovation hub and knowledge region economy in Africa. We are a cross-sector and interdisciplinary membership organization that brings people together from businesses, academia, government, and civil society to meet each other and to share ideas, encouraging collaboration and partnership for greater shared success and in support of a strong innovation ecosystem and inclusive economic growth. We've grown the network by offering the following, even through COVID. I mean, launching in November 2019 was a great idea, and then strikes December, January, COVID. So through webinars like these and here and there a few events, we've managed to host events online or in person. We do various events ranging from technology training workshops or innovation workshops to Stellenbosch Smart City Lecture Series. We've launched an ideation challenge in 2020 called the Ideas for Change Challenge, which had a fantastic outcome. And I know one of the participants and finalists in the challenge is also here today, Renee Musikeni. So our focus is to get new great ideas, to work with these people and to help them to establish them to grow. We're kicking off our next challenge in September 2021. Our website, stellenboschnetwork.co.za, is also our database. We've grown our members to 170 more or less, and these range from corporates to SMEs and entrepreneurs in the greater Stellenbosch area. We share our news. For us, it's very important to share the news of the area and what's happening. With the assistance, of course, of Loudhailer, we send out monthly newsletters with stories about member companies, events we are hosting, and also a great monthly feature called Entrepreneur of the Month, where we focus on a local Stellenbosch-based entrepreneur. And then, of course, we share our news via social media. What we do for matchmaking, as I mentioned, we try to work with entrepreneurs from the start, growing them. We also have a mentorship program where we, at the moment, have 10 entrepreneurs that runs on the 8-month program. We really aim to be the golden thread in Stellenbosch that brings businesses and people together to establish the area as a knowledge region economy in Africa. So please do follow us on social media, Stellenbosch Network, and also register your business on our website. It is for free if you are in the greater Stellenbosch area. Thank you very much.
Thank you, Hanli. Super to hear from you. And I think the Stellenbosch Network is a great initiative. And I think there's many great things that kicked off during COVID, whether they intended to or not. But we've seen some phenomenal things come out of this period. So not all doom and gloom.
No.
Right, Apandile, it'd be wonderful to hear from you. Thank you for joining us from Cliff Decker Mayor. Who are you? Tell us who you are. Hello.
Hi everyone. My name is Apandile from Cliff Decker Mayor. I'm a senior associate at the firm's TMT, Technology, Media and Telecommunications. Part of what I do is privacy, and in the past few months, I've been slipping and breathing POPI, which is why I'm here today, and hopefully I can shed some light on what the legislation is about and what it is you need to do in order to be compliant with the legislation. Can I go ahead and start sharing my slides?
I think Apandile, let's Tian do a quick intro, but we're so looking forward to your crash course in terms of the legislation around POPI. Tian, why don't you just quickly introduce yourself?
Sure. Hi all, I'm Tian van Zyl. I work for a company or an agency called Traffic Brand Analytics. We've been around for about 10 to 12 years. It's escaped me now, really. It's quite long for an agency within the space. And we've had the pleasure to work across many verticals, from retail to genetics, to property, to banking. So I think we're kind of well-versed. We've seen a lot of what happens within the South African space. And hopefully with the POPI Act and what we've had to deal with our clients and get them kind of up and running with POPI within the digital space, I can kind of share our experiences with that.
Super, thanks, Tian. So for everyone who's joined, just a quick reminder, please share with us who you are, where you're from, what you do, share your LinkedIn so that we can all connect and strengthen this community. As a reference, we are looking at both the legislation and compliance side of the POPI Act, as well as what it takes to be compliant on your digital and social channels. And this is relevant to all startups, innovation partners, and anyone working in the innovation space. So I see we have lots of educators, service providers, lawyers, and I think that we can all stand to learn a lot tonight. Right, let us kick off. Apandile, the floor is yours. Please educate us.
Thank you, Kathleen. Let me just try sharing my screen. Just one moment.
We'll be having questions at the end. So for those of you that have questions, just stick around, pop it in the chat box. We will be scrolling through and collecting your questions. Daniel encouraging us to come to Stellenbosch of Eendracht Hotel. Please come and visit. Tourism needs you. Any Cape Townians, yeah, head out to Stellenbosch for the weekend. Right, Apandile, are you ready?
Yes, I think I'm ready. Is my screen visible?
Not yet.
Just give me a moment.
Not a problem. Right, for the rest of you, please keep on posting in the chat section. It's really interesting, and for those of you who want to connect with each other, this is a great opportunity to see who is active and energized in the innovation ecosystem, and it's always good to work with those who are ready to work with others. Right,
Okay.
so Apandile, we can see your presentation, and this looks super.
Excellent. All right, I'll start right away. I do want to start just by saying that, the time that we have today, even if, the entire 2 hours was allocated to me, it still would not be enough for us to go through this legislation, in the detail that it deserves. So what I will do, the approach I'll take is to sort of give everybody an overview of the legislation and just some of the key principles that you can use when you encounter processing of data, and see how this legislation applies to you and how you can be compliant. All right, so you wonder what POPI is. POPI is the Protection of Personal Information Act, number 4 of 2013. This has been a law since as far back as November 2013, when it was signed into law. Some of the provisions of the legislation became effective the very next year. That was not all the provisions of the legislation, with the rest of those being effective last year, June. And in terms of the legislation, we were given a grace period. Companies were given a grace period of a year to be compliant with the legislation, and that came to an end by 30 June, which then meant from the 1st of July 2021, everyone who processes information, specifically personal information, has to be compliant with the legislation. What does this mean for you? As you will understand, we all deal with data on a daily basis, whether you are processing data or you have somebody processing your data for any reason whatsoever. So if you are processing data, you have to be compliant with the legislation, which is POPI. Why this is relevant for anybody processing data as what's called a responsible party under the legislation is that if you're processing data and you're not compliant with data and you encounter a breach, there are some obligations that you have in terms of the legislation, including reporting the breach to the information regulator, as well as the data subject, being the person whose information you were processing. The person whose information was exposed or compromised because of the breach. Without going into too much detail and giving too many examples, I've selected one example that you may be aware of, the NetBank breach that took place sometime last year in August. What I want to point out specifically in respect of this breach is the fact that NetBank systems were not, in fact, breached or compromised when this breach took place. In fact, a third party that was engaged by NetBank provide some services to Nedbank. It's their systems that were exposed, so the breach didn't actually happen at Nedbank. So it happened at a third party who was processing data on behalf of Nedbank, who was processing data of Nedbank's clients, which means it's not enough that you are compliant as the responsible party. You need to ensure that your operators, being the person who processes data on your behalf as a responsible party, you need to make sure that that person or that company has the right measures in place to protect that data. And the reason for that is the fact that when there's been a breach and data that you process for your customers or your clients, and data that's being processed by any operator that processes data on your behalf, you would be responsible as the responsible party for all that data. You wonder what a responsible party is. A responsible party, in the simplest of terms, is the person who is responsible for the processing of that data. So if you're collecting data from your clients or collecting data from third parties and you're processing that data, you are likely going to be what's called a responsible party, because you then determine the means of processing that data, either individually or collectively with other persons. And you wonder what a data subject is. A data subject is defined in terms of the legislation as the person whose information you'll be processing. But before we even go into what the effect of you failing to comply with the legislation and what you may be liable for, I think we just need to sort of establish basic terms that are very important for your compliance with POPI. So you first need to understand what personal information is. What comes to mind to anybody is somebody's name, surname, cell phone number as personal information, but the definition in terms of the legislation is much broader than that. In terms of the legislation, it's really any data that can be used to identify a natural person or a juristic person. And the next thing that you need to understand is a definition of what processing in fact is. Processing really is anything that you do with data that you have in your possession. So this could literally be, as long as you touch a data subject's data, chances are whatever activity that you're performing in respect of that personal information would qualify as processing in terms of legislation. The reason you need to be compliant with the legislation, other than the fact that you may be exposed to fines and you may sometimes be exposed to imprisonment, are really the risks that are associated with any non-compliance or breach of data. First, you have a risk of reputation. If your clients or customers' data has been exposed, you have to, once that's been done, you obviously have the obligations you have under the legislation, being those of reporting the breach to the information regulator and reporting to the data subject that there's been a breach. But you have to take some mitigating steps in order to restore your reputation as a data processor and a responsible party under the legislation. There's also the issue of business interruption, and you may face some issues with your business continuity, because once there's been a breach, it cannot be business as usual. You have to do that which you need to do in order to make sure that any risks associated with the breach are properly mitigated. You probably have to communicate with your stakeholders, shareholders, and really any person who may be an interested party who may have an interest in the breach and the data that you may have had, including your business. You may have to undergo some overhauling in respect of the technologies that are used in order to process the data that you process. One of the biggest risks, which would be very critical for you, especially after the 1st of July 2020. So the regulator is in a position now where they can take steps in order to enforce the legislation. However, because they simply don't have the capacity to go after everybody right away. However, if there's been a breach, if there's been data that's been exposed, and you've reported that, you are effectively inviting the regulator to, to conduct some investigations in respect of your business, your operations, and how you process data. And who knows, they may, simply because you can't really have a certificate of compliance where you say you are certified that you comply with POPI, because generally compliance is an ongoing thing. You may very well be compliant today, taking into account risks associated with the data and the sensitivity of the data, but you may very well not be compliant in the next 6 months. So, the last thing you need is the information regulator poking into your business, and you are found wanting and exposed to fines and penalties. And there's also the cost relating to damage control once there's been a breach. You may have to do some PR, you may have to, publish some information relating to the breach, and really you want to avoid that as much as you can. What you want to do, you don't want to sit and not take steps that are necessary to ensure compliance. You don't want to be caught unexpected. You want to be proactive in managing your data, in putting in place the necessary strategies, and setting up the information office to ensure that you've got the right steps in place should any breach happen in respect of data that you are processing as a responsible party. We've already mentioned that in order for POPI to apply to you, subject to some specific exceptions that are set out in the legislation, you need to be processing what's called personal information in terms of the legislation, which, as I've mentioned, is any information really that can be used to identify a person, ranging from names, contact numbers, ID numbers, location, photographs. It really can be anything that can be used to identify a person. A responsible party can be private entities, it can be individuals, it can be public companies, really anyone that will be processing information or personal information specifically would have to comply, depending on the role they process, on the role of the processing in terms of the legislation. Of course, in order for you to understand what it is you need to do, you need to know what personal data is. There's the obvious types of data, which are name, addresses, localization, online identifiers, health information, etc. But there are also some types of personal information that are not so obvious that you may not at face value understand to be personal information. But if you use the principle that certain types of information may be used in order to identify a person, then the data that you're processing may be personal information. You would see on the screen that we've categorized personal information into three. We've got what I've categorized as physical data and personal proclivities, and that's the obvious stuff. As you can see, things like age, marital status, gender, and we've got another category which I've named applied historical data. That would be things like educational background, work experience, previous convictions, things like medical history. That's also personal information. And the last category, which is the least obvious out of all of these, is numbers, symbols, and contact details. Telephone numbers, ID numbers, geolocations, all of those, either on their own or in combination with other types of information that you may be processing, could constitute personal information in terms of the legislation. So you always want to be careful, and where you are not certain, consult with the relevant privacy officer within the organization or the information officer. The legislation requires you to, if you're processing any data, ensure that you put in place the appropriate, reasonable technical and organizational measures to prevent any loss or unauthorized destruction of data. Now, what is interesting about POPI and many other data processing legislations is the fact that it won't tell you what specific technical and organizational measures to put in place. So what measures you put in place will often depend on the type of information that you're processing. So POPI doesn't tell you to put firewalls in place, or put this kind of lock if you've got physical records on your cupboards where you store your data. So the level of security that you apply to your data really would be determined by the type of information that you're processing. So what's appropriate for a certain type of a record may very well not be so appropriate for another type of record. So you always want to look at the type of record that you have to process and look at the sensitivity of that record, and then apply what's reasonable and what's appropriate for that particular type of record. The measures that you put in place, it's not enough to put measures in place this year that are appropriate. You need to, on a regular basis, revisit the measures that you do apply and ensure that they remain reasonable, appropriate, taking into account the types of information. I'm sorry, I don't have time. Caitlin, if you could just keep me honest with time and just...
Yeah, no, I think we're very interested to hear what you have to say, Apindile. I think possibly a few more minutes for you to go through additional information. I mean, this is the foundation of what we're trying to understand.
Yeah, terrific. So like I said, most of the times, it's really, POPI is really a principle-based type of legislation. Nothing is ever what it seems. It looks very simple when you're just reading the legislation, code, until you have to apply it to a specific set of facts. One of the things the legislation requires you to do, in fact, what the legislation requires you to do in order to process any type of data, you need to have a legal basis for processing the data. I'm sure we've all heard or seen people requesting us to give them consent to process data. So almost everybody, has an understanding that, in order for your data to be processed, you need to consent. But what lots of people do not understand is the fact that consent is just one of the bases for processing of information. There's about 5 or 6 bases for processing of data under the legislation, and all of them are as valid. So it may very well be that you didn't give consent to the processing of your information, but your information is being processed in terms of another basis of processing under the legislation. It may be that it's being processed in terms of applicable legislation. It may be that it's being processed in terms of an existing contract. It may very well be that the responsible party is processing the data in order to fulfill their legitimate interest. The point being that all of these bases for processing are as important as the other. So the fact that, for instance, your consent has not been obtained, or that you have not given consent to the processing of your data, may very well not be a reason for you to lodge a complaint with the information regulator, because the person who's processing your data may have another basis for processing of the information. Some of the risks, in fact, one of the biggest risks that one may have to look at as a responsible party, the risk relating to physical records, paper-based types of records. Probably not today because we're working from home and we're not doing too much printing. But when we still worked from the office, you would print you would print something and you would not collect it from the printer, which would then mean everybody that has access to the printer may have access to the record that you would have printed. But that practice would, in most cases, fall short of the requirements of the legislation, in the sense that you would probably be having people that do not have to access that information, accessing it, and in so doing, you would be falling short of what's required of the legislation. Another, Caitlin, you want to say something? Caitlin, you're on mute.
I'm listening in, and I think we are teeing up to hand over to Tian soon, but I think these are important conversations we need to have.
How long do I have?
I think let's take another 3 minutes, and then we can hand over to Tian.
All right,
Sure.
I'll be done literally in 2 minutes. Thank you very much. So I think what's relevant for most people today, after the 1st of July 2021, and most organizations would have seen this, especially after the unrest that we saw in the past 2 weeks, and the looting that took place. Some people's businesses may have been vandalized, and some equipment, some technological equipment and devices may have been stolen, and some of those devices may have had records that contain personal information in them, and you may find yourself having your data subjects data being exposed, with the likelihood of that data being accessed by people that aren't authorized, and you may have had to report that breach to the information regulator. And just with the last few seconds that I have, I do want to just mention that our legislation, which is unique to some of the prominent data protection legislations in the world, there's not a certain level of exposure to data that the exposure needs to reach in order for that to be reportable to the information regulator, as long as there are reasonable grounds to believe that personal information of a data subject has been accessed or acquired by an unauthorized person, is a responsible party or an operator, you have an obligation to report that breach to the information regulator. You have to also inform the data subject, unless you're not required to in terms of the legislation, for instance, because you cannot establish who the data subject is. There are some timing requirements under the legislation. You are required to report a data breach as soon as reasonably possible, following the breach or suspected breach to the information regulator, as well as the data subject. Lastly, before I close, if you are found wanting and if you are found to have failed to process data in terms of legislation, you may be fined up to 10 million by the information regulator, and there may be some imprisonment up to a period of 12 years. So the consequences are quite serious in the event that you are found wanting. I will stop there, and I will take questions at the end of the session.
Thank you so much, Apandile. I think this is, as you said, such a difficult topic to cover in 15 minutes, really. But obviously with dire consequences. There's a couple of good questions coming through, which I'm just going to read out, not for responses now, but Tian, as you present, if you've got any comments on them, you can incorporate them. I see there's some questions coming through here saying, some frustrations around why are the lawmakers never ready with data systems? Why do we still have to submit pages of information to the officers? Good question. Another one, is MFA mandatory as a security safeguard? Another good question. Does anyone know how the POPI Act will affect the payment space? And then I think the big question everyone's been talking about, if we have historic data that did not have consent for, so for example, we have our email newsletter database, can we legally still use this personal data for marketing newsletters? So Tian, I've got a feeling that some of those questions fall into your space, and Apandile, we will revert back into the Q&A session after Tian's spoken. And yeah, one quick question again, can I conceal / hide personal information? Ryan, with those thoughts, let's hand over to you. Please share your.
Okay, great. I'm just going to share my screen quick. Please let me know if you can see it.
We see it perfectly. Thank you, Tian.
Okay, great. So digital. Look, I think that the POPI Act really has helps you understand what to do with your customers' personal information. I do want to bring kind of or highlight the fact that digital plays a role in that. And I think everyone that's kind of been in this ecosystem is asking the same thing, is that how, if I'm on Facebook, if I'm on a website, if I own a website, what are my obligations to my customers and my users on there? So I think let me take you through that. I kind of, as an agency that's been around throughout the years, and as an agency that focused on advertising and the understanding of the analytics behind advertising and customers, we really had to deal with these kind of questions throughout the year. So hopefully these experiences will help you, and I can answer your questions at the end. So yeah, let me take you through. Let me just lay a little bit of a really good stats to show you how big the digital space is within South Africa. Look, we are not the US. I don't think we pretend to be some of the Western countries, but what we do have is a really good internet penetration. I think about 64% of the South Africa population has access to the internet. And the pandemic really matured this digital industry to quite an extent. To give you an idea, the e-commerce industry, the e-commerce space within South Africa doubled in what they sold in 2020. So it's about 30 billion rand in revenue, where 35% of the South African population had bought at least one product. But still, the retail e-commerce space is still 4% of total retail market. So you can still see that there's a lot to do. And with all of that comes a lot of data. Now you can see that the POPI Act really came into a crucial time where companies are starting to go online more often. If you're not online, you're kind of missing out. And then what do you do with it? So on that, the idea around digital is not different to how you process some of your personal information. The idea is that if you care about your customer, then you should care about their privacy, right? There was a Deloitte did an online shop report for 2021, and out of the 4 elements that define a great customer experience, 2 of them have to do with privacy. The one was, how does the company that I give my data to, how do they protect my data? And the other one is, can I trust the brand? Now you can see that if I can't trust the brand to protect my data, that there's 2 vital elements to what your brand might be losing out. And so, yeah, I do think privacy plays a massive role in the online space. So I'm just going to recap a bit about the way cookies work. Look, I think that there's a little bit of a misunderstanding of cookies and what are cookies and how do they use on the internet. So what you can see though is that there are kind of 3 types. You get first-party cookies. Those are usually when you go to a website and you log in. Those cookies typically stored by the company themselves. So, and they are there to kind of remember your logged in status, how many products you have in carts, etc. You get third-party cookies, which are stored or kind of stored on your browser by other domains. So these are typically kind of Google, Facebook, and so on, and they are the ones tracking you across the web. And first-party data. So that's data that the customer is actually given over to you, kind of in exchange for a product. So if you buy a product or you sign up for a service, you give your name, telephone number, etc. And that's the 3 kind of. But this environment is changing quite rapidly, right? So in the next couple of years, and we've seen it up until now, that third-party cookies are falling away. What does this mean for the industry is that and I've got 2 small case studies of the way the 2 big players in the globe are kind of approaching this, is that third-party cookies are falling away. And this is really where the industry is changing, and the impact on digital advertising especially is going to play a massive role. And also in your web analytics platforms like Google Analytics. To show you, and the 2 case studies are kind of major players within in the global space. The first one is by far the biggest online advertiser in the world, and the second one is very much product focused. But the one thing that they have in common is that they have privacy as one of their key pillars. The one is Google. Look, I don't think it's any surprise that Google is the biggest advertiser in the world. Their browser dominance around the world is about 65% of all browser usage is on Chrome. South Africa is 71%, a little bit higher, and their current cookie usage status is it's not restricted. Look, I think that their advertising business is built on third-party cookies for now, and the use of cookies and how do those get processed, because Google Ads, their targeting is based on the way that they process the cookies, and your targeting based on interest are based on this. But they are by 2022, I think from what I read now, 2023, going to phase out third-party cookies. But they are working in the background on something called Flock, or federated learning of cohorts. Basically what this is, in layman's terms, is that they're going to group people or create groups of people based on similar interests. Now you can see this is something that is, so how that differs is currently Google kind of follows you with an ID across with a third-party cookie and understands what kind of website you visit and so on, and it builds a profile of who you are, what you're interested in, and then the advertising space can then target ads based on that interest, whether you're in market to buy something, etc. The difference here is that this is not ID based. It's based on kind of the same principle of how are you, which websites you visit, etc. But it's never exposed to Google at all. Look, this is still a work in progress. And the three key pillars that they're trying to accomplish with this is to prevent tracking across web. The other one is to build privacy-focused publishers. A very big part of Google's stack is to say that our publishers, to be able to show a banner of your product on someone's website. And the other one is still to preserve an open web. It's kind of key to our freedom within web. So this is very much a software or advertising-based company. Now, the next one is very product-focused, but their key focus here is still privacy, which is Apple. And I think Apple's, if you've been following their keynotes over the last couple of years, they've really been, a very big part of their keynotes was focused on privacy. It's one of their top selling points is that they are a company that have privacy as part of their product development. And what you can see, their browser dominance is about 18%, 11% in South Africa. It's due to the kind of product level of how the products cost, etc. And the cookie usage really started, I'd say it's really started with ITP. I think it's back in 2016, if I'm not mistaken, where their first version of this restriction of cookies were on third-party cookies. Now, ITP 2.3 came in not so long ago, where first-party cookies only had a lifetime of about 7 days. Look, I'm not going to bore you with the detail of this, but there's kind of implications to this where attribution plays a role, etc. But and then the future. So iOS 15 is being launched soon. I think it's in September, and two key pillars of that launch is the prevention of tracking. So if you've ever run an email marketing campaign, in your platform, you get things like opens, what percentage of people that it was delivered to open it, and it gives you a really good understanding of how effective that your kind of email marketing is. So what iOS 15 is going to do is it's going to stop allowing people to track that unless they give consent to do so. So you can see that there's a very big privacy focus around products. Now, look, but we are not Google or Apple. But the key thing here is to know that what's good for the goose, good for the gander. And what this means is the laws aren't designed around companies, they're designed the customers. So if it's good for someone like Apple or Google, it's good for us as smaller companies too. And it's really important to understand that the law was based on the customer. So let me give you a quick rundown. Okay, so before I get to that, and what is really important to understand is there's a relationship between a company and a customer. And that's really important to understand. I think sometimes myself as an analyst, we work with a lot of numbers. And sometimes it gets lost, the fact that you're working with a customer that sits at the end of those numbers. And as a company, it's important for us to understand that those numbers, there are people that sit behind it, and we have to respect those numbers. And the fact that they give us permission to use those numbers to improve products, to improve marketing, to improve the experience that we give customers, it is vital. So, and I think it's with technology on board, is we sit with technology that allow us to change environments and change security quite quickly without having to go through paperwork, etc. So it's really important to make sure that your business, from a digital point of view, is up to scratch, and that you don't lose that connection with your customer. And make sure that privacy is part of that relationship, actually. Now, I just want to show you how typically it works from a digital marketing point of view and where privacy really plays a role in there. So typically how this works is that you've got a digital marketing team, and the idea is to get something promotional over to your customer, right? So it's either you want to push a banner in front of them, or if they're searching on Google for something, that you are there when they are searching for it. Two ways to do this. There's interest-based targeting. So if you've ever run kind of a social media ad, they ask what is the kind of interest that what are your targeting interests that you want to target, or you can use first-party data. And really, this is where the POPI Act plays a massive role in which I'll get to know. Now, the two teams, in bigger companies, tends to be kind of a marketer and an analyst. And the marketer's position in this is to understand the marketing platform, policies in there, which ad units work, how do they work, and best execute the strategy that the company needs to have on board. The analyst is there to understand the information that sits behind it, how big is the addressable market, and so on. Now, the thing is, once you've targeted someone with an ad, right, you want to get them to your property, your website, your app, whatever that might mean, and they take you kind of up on this offer. Now, here's where your responsibility really starts, is that once they get to your website, you're kind of inviting them into your home, into your business. So it's really important that you take action and protect their privacy here. So, and companies tend to use quite a few products here. Things like Hotjar. Hotjar is one of the more popular heat map tracking platforms. Google Analytics is web-based. Analytics platform understands user behavior without tracking personal information. But there's kind of a caveat to that. Cookies are still fire, and that's really important to understand. Facebook and Twitter, as advertising platforms, they ask you to put their scripts on your website so that they can understand when you've actually shown someone an ad and they've been to your site, what happened on the site to be able to justify the ad spend, right? Now, there is where the controversy starts with someone like Apple and Facebook. They're kind of in a bit of a squabble because they said that in order to give a user a good experience, we need to track them onto our client's website. And Apple says, no, it's actually not up to you, it's up to the customer and to enable you to do that. And I think that's really where POPI thing also comes in. So, and then when someone actually signs up to your service or your product, basically what they're doing is they're giving you their information in exchange for product. And I think it's key to understand the fact that once they've given you the information, you are the custodians of it. And in that sign-up process, you have to make it explicit, the fact that what is this information is going to be used for, what is the lifetime of it, and if they want to opt out to it, they can. And within marketing and customer analytics, there are kind of two things that you tend to do with this kind of information. You build models around how to retain customers. So once you've signed them up, how can you retain them? And the second one is, how do you find similar profiles? And this is really where it becomes interesting. So that this information can be fed back into advertising platforms, right? So if you have not explicitly made it clear to your customers when signing up that this information might be used for remarketing or retargeting purposes, then you're actually not allowed to do so. So it's very important that you make clear within your privacy policy what your first party data is going to be used for within marketing respects, etc. So it's really important that these cookie-based and first party based data is used with respect to your customer. Now, mentioned earlier, your third-party cookies are becoming a little bit obsolete, and the problem is with that is it makes tracking across the web quite difficult, right? Because now all of a sudden, technologies that you were relying on to give you as much information as possible about your client are simply not working as they once used to. I think we've become quite we've we had kind of free will, right? To track everyone that came to your site, to track everyone on across your properties. And now all of a sudden you need to actually ask users to give you consent to be able to track them. I don't know if you've probably noticed that if you go onto certain websites that you have there, they've got those banners that say, if you give me consent that I can be able to track you, either with marketing or analytics or necessary cookies. Now, each of those have a particular function, and what companies are asking you to do is to say, I give you consent to track me within each of these platforms, and then to do remarketing with, or because an analyst sitting within this space, the more information we have, the better it is. But being a kind of a customer myself, naturally, but also being a company owner, I know the obligations of a company to be able to say, or letting customers give me consent to do so. I think there's kind of an argument is that, do you want to analyze data of customers that don't really want to be giving you consent? No, you don't. So it's kind of respecting the user's privacy, right? So now what can you do from here? So if you've got a website, I encourage you to start looking at consent management platforms. Look, there's two ways of either going about it. You can either build your own, if you've got the resources in terms of from a development team, etc., or you can go with pre-built platforms. There are quite a few, such as CookieBot, Usercentrics, etc., that have built these platforms that allow you to control cookies on your website. And then when someone visits your website, you've got a banner that pops up to say, do you consent for me to track you once you get to the website? And they kind of manage it for you. But naturally, then there's kind of a subscription model that they apply to it. With that, you also have to update your privacy policy on your website to reflect these changes. And also, I would encourage you to go and educate yourself on, when you do run ads within an advertising platform, to understand their privacy policy and make sure that they also comply to the local laws. And this last one is to ensure that your first-party data strategy is in place. Look, I know that this first-party data strategy is very much it sounds like more of a bigger corporate strategy, but it's not. I think in order for you as a company to grow and make sure that your customers receive the best service, it's important for you to also collect consent information and understand your customers better, to give them a better experience. Yeah, and I think that is it from me.
Thank you, Tian. That has been very, very informative. You know, sometimes it's very useful to get into the absolute practical. I think perhaps, Tian, if I could just kick off with you straight away, with you speaking a lot about websites, do you have any insight on what people with big databases and mailing should do specifically? Like, can we recap on that? Everyone's saying, but we built up like databases over years and years and years. How can we just let them go? I mean, what is your take on that?
So as far as I understand, is that if you have historical data within your database, you can still email to them. You should make them aware that they are still in there and give them an opportunity to opt out if to be part of it. As for asking for consent for new users that do sign up, you kind of, what a lot of websites tend to do nowadays is that they, within your newsletter sign up, as an example on your website, you would have another tick box that says, I do consent the fact that this would be used for marketing purposes too. That's what people, just to get that extra layer on it. Yeah,
I think people have been quite afraid that if they provide that option for people to opt out, that there would be this tremendous drop off, and that it would you know, announcing efforts. I don't know if you guys have had experience. I thought it was interesting what you said now when you said, do you really want to analyze data from users that don't really want to be engaged with your product? It's a very fresh take on it.
Yeah, I think it's an interesting debate really is that if I had to, I always try and take it back to kind of a real life example, is that if you're going to put analytics as an example on your website, and you think about that as a physical shop, everyone that comes through your door, if I ask every single person coming through the door, am I allowed to communicate with you any marketing efforts? The people that say no, why would I then go and force my communication efforts on them? And I think we can do that. Technology allows us to do that at scale. So if people don't want you to communicate to them, don't. I think if you look at performance within your marketing platforms, communicating to people that really want to be communicated to will show in your performance metrics. And I think that's kind of the bottom line. So
that's very useful. Thanks, Tian. And maybe perhaps still on databases and marketing. Apandile, do you have any thoughts on this? You know, we talk about huge data breaches with the banks and personal information like ID numbers, etc., leaking out, and that obviously being incredibly distressing. But when it comes to compliance and legislation, what about the rest of us who are sending out mailers and working on social media? What sort of risks are we facing?
Yeah, that's a very broad question. That I don't know
it
that
is,
I fully
and you are welcome to
understood
tailor it down.
I don't know that I fully understood, but what I do want to say is, I think the only relevance of the industry you're in is the level of sensitivity of the data that you process. I don't think the legislation, allows you to process data, in a way that's not in line with the legislation, simply because you're a plumber and not a banker. I think we all, if we're processing information in terms of the legislation, we have to comply with the legislation. I don't know that I answered your question.
Yeah, and perhaps you don't have the answer. And I think as a Silicon Cape and a Stellenbosch Network, we're going to keep pursuing these answers until we have a super strong FAQ and learning from other entrepreneurs. I think the concern is, do you think there will be fines for entrepreneurs who aren't prioritizing compliance? Somebody here, Misha, mentioned, if you are GDP compliant, does that mean you're POPI compliant? And then, thank you, Quentin. I see you've answered that, saying no. And I think that's one of the questions is, when being compliant with regulation, we have to prioritize our efforts as entrepreneurs and marketers as to what we give our attention to. So, is this something that is critically important? Do you think we have more time? Do you think we'll be fined for it? And if you don't have the answer, that's also fine.
Yeah, no, I do have an answer. If I may, and you can probably comment, Tian. Yeah, I think you do have to comply since, from the 1st of July 2021. And if you're not compliant, the regulator can come after you for your failing to comply with the legislation. Data subjects, being the persons whose information you're processing, can lodge a complaint with the information regulator, and you may be fined, a fine up to 10 million, and there may also be imprisonment up to 12 years. These obviously have not been tested. We haven't seen anybody go into prison for having failed to process data in terms of the legislation, but everyone who processes data, specifically personal information, has to comply with the legislation, regardless of the industry they're processing data in.
Right. I think we do know that. I think we were hoping you had a different answer, but let's continue. Sibusiso Koza, wonderful to have you on this call. He's asked here, do we need to explicitly mention on our terms of service that we adhere to the POPI Act? Or can we just list all the guidelines of POPI around the information we collect? So how explicitly do we need to display our compliance to the Act? Tian, perhaps have you had experience with this?
Look, I think that it comes down to that privacy policy. So if you've got something like a website, if you cover everything within the act, it would then be POPI. So I don't think saying explicitly that you're covering POPI as an act is necessary, but if you are covering the points that within POPI necessary, then of course then you're covering what you should. So I think within your privacy policy, you have to be certain the fact that when the information that you do collect, what is it used for, how are you going to use it, and why you're using it. And I think collecting information that is only necessary is the best use case.
Yeah, very interesting. I see a new question that's come up here from Daniel Wallman, a familiar face. He's Tian, directed to you. With the changes in digital privacy and tools moving away from providing user-based demographic granularity and moving more towards behavior or engagement-based, what would be the best way to analyze your data, and how would you use that for your marketing and communications?
That's a really good question. Look, I think that it comes down to that first-party strategy, and I think first-party strategy, data strategy, does not only mean from an analytics point of view. So first-party data necessarily means that you've got information about the client, ID numbers, phone number, products they've bought. That's information that sits within the business. I think that is going to become critical for any company to better understand and get better at, because naturally your compliance around that should be kind of quite in effect. I do think, though, if you look at third-party vendors, something like Google Analytics, what Google has done over the last couple of months and so on, they've launched a kind of new version of Google Analytics that move away from user-based tracking to something like event-based tracking. So standing around privacy of third-party cookies and first-party cookies have changed their fundamental way of tracking as well. So the best way that you can use data, always have first-party data as your first point of contact of analyzing and communicating via email marketing, etc. if they've given you consent. But also use your aggregated tools that you do have and people have given you consent to, and use that within marketing and communication too. There's no one tool that rules it all. I think, yeah, if you've got a strategy across the platforms that you use, it's definitely the most effective way.
Yeah. And then I see that, Michelle, you had a question, yeah, saying it's a very practical question around privacy. Can we still post photos of our restaurants that show guests sitting at tables on our social channels if it doesn't focus on any one guest? And I see that we do have a response here from Quinton, who said, Michelle, photographs are included as personal information. For example, the information regulator is taking on the Department of Correctional Services for allowing photographs of Zuma in prison to be taken. Apandila, do you have a comment on that in terms of photography and the POPI Act?
Yes, I do, and that is absolutely correct from the comment that photographs would constitute personal information, and any processing of those would have to be in terms of the legislation. I think I've actually looked at this, and I think one of the comments that we had received from one of the participants was whether a disclaimer on the door into a restaurant would be sufficient to obtain the customer's consent for processing of that data, and whether legitimate interest could be used as a basis for processing of that information. I think processing in terms of legitimate interest is a very tricky one, especially because it has not been tested in terms of POPI, because POPI is new. We don't really know what it is that constitutes legitimate interest. We can look at what's been looked at in other parts of the world, but locally it has not been tested. So I think before one relies on legitimate interest, one has to carefully look at the processing and make sure that it does indeed fall within the basis of legitimate interest. But I think the best way to process data of your customers as a restaurant, for instance, would be to really just get their consent. And while it is advised that your consent has to be in writing, but it's impractical, to get consent of all, 100 customers within your restaurant. So I think this can also be done, for practical reasons. Verbally, you can ask the customers to give consent to you taking their photos and posting them on your social media platforms. But I think the best way to do it, to be safe, would be consent, and a disclaimer would fall short of consent as required in terms of legislation, which should be, specific, and it has to be, intent, and the customer has to specifically consent to your processing.
Absolutely. And, realistically, I know it can be very frustrating for people that are just trying to market and run channels. But the reality is you cannot take a photo of somebody and distribute it for an intention that they did not agree to. And it's that simple. And I think living in an era with facial recognition, people have very real fears about having their face, their names, their information on the internet. We have to now get creative in terms of how we're doing our marketing. Right, we have a question here. Peter Morgan, I can feel your pain through your question. Everyone is sending POPI emails saying that they have my data. It's driving me crazy. From my side, do I now have to email all our clients and contacts saying that we have their data? Tian.
That's a really good question. Look, I agree with you. Those emails have been driving me crazy too. I do think there's a reason for it, is that they want to give you the opportunity they want to understand whether you are part of it and give you the opportunity to opt out if they don't want to receive information going forward. So whether you have to, I can't give you an exact right question. Whether you, as a company, feel that that is a policy that you want to go out and communicate the fact that you do own, you have the information, even if it is older information, I think that might be the right thing to do.
Apindile, do you have something to add around if you are sitting on data, are you now compelled to notify them you have your data?
I think like Tian said, I think the entity or the responsible party would have to determine what they want to do, but I think it's safer to take that course of action and inform people that you are sitting on their data and you may be processing it in a certain way, just to be safe. I think you always want to take a conservative approach to the extent that doing so is practical.
Yes, and perhaps another question for you, Apindile, is Imar Kricha has asked, is every business required, even a small business, to register an information officer with the information regulator?
Yes, that is correct.
So all of us, if we got a PTY, a CC, a partnership, we've got to register our information officer. Is that correct?
That is correct, yes.
Well, you learn something new every day. Right, let's see what other questions we have. I think we had a question here about service providers, and there's been some conversation here. What about service providers who are third-party vendors? So they process personal information on behalf of the company, or by virtue of the nature of services rendered, they may encounter personal information when providing support to the company. What should be done in this respect? So can I just correct that? So Stephen, I know that was your question and you're welcome to speak up if you're still on the line and ask your question directly. But am I correct in saying sometimes information gets passed on to you that is not directly coming from the client and you kind of deal with it by the way? Do you have to be handling it with all the virtue of the new POPI Act? Tian?
Maybe I can use an example of what we have done as an agency. So look, within digital marketing, you do work with anonymous or aggregated data more often than not, but there's a specific aspect to advertising where you can upload customer details and remarket to that group of customers specifically. Now, the way that you transfer that information from client to agency is where the kind of problem then starts. It's that kind of a third party processing on behalf of the third party as a third party, right? And I think it kind of stepped on the same question that you had, is that what we had to put in place is write down the whole procedure. And so that you know, I'm the information officer at our company. So as the analyst kind of working with data, also naturally became the information officer as well. And what we had to do is to make sure that the process was fully understood, written down, and the process, the steps within receiving information, processing information, and the use of it was done in a lawful manner. And I think what we did with that exercise, we really found the best method of doing so, and the most secure way of doing so. And I think as an agency, going through that process helped us understand where we were lacking and where we were not. And it was good. So as a third party, you're still obligated on behalf of your customers or your clients to be lawful in that sense.
Yeah, thank you very much, Tian. And then Quentin, I want to thank you for being so very engaged with the colleagues on this call. Quentin has a question for Apandile saying, so if it's a small business, can the information officer also be the responsible party?
So I think those are actually two concepts. An information officer is an information officer, being the officer appointed to ensure compliance within the entity or the responsible party with the legislation, whereas a responsible party would be the organization itself, being the entity that determines the purpose and the means of processing of data. But it's actually two things. Information officer is a person, and the responsible party is the entity itself.
All right, super,
Does that
thank
make
you.
sense?
I think so. Right, we have two last questions, and then I'm going to start closing off for the session. And again, if you have answers, Tian and Apandile or anyone else on the call, please do reply. A question from Liesel Brits. Is MFA mandatory as a security safeguard? Tian, is that within your realm?
No, it's not. Sorry.
Not a problem. Apandile, is that something you're familiar with?
Sorry, just repeat the question again, please.
Is MFA mandatory as a security safeguard? And Liesel, if you're on the call, you're welcome to speak up. Multi-factor authentication.
So first of all, I don't know what that is, but I do want to say, just generally as a principle, there isn't a specific security measure that the legislation, would prescribe. You'll remember we said generally POPI is a principle-based legislation, so it won't tell you what to do exactly, but based on the information that you're processing and the industry that you process that information in, you may have to put in place certain measures. So perhaps a measure that you've just described or mentioned may be necessary, taking into account your industry and the information that you do in fact process. But POPI does not specifically require you to put specific security measures in place to protect data. It just requires you to put in place reasonable measures to protect the data processing.
And I think, Apandile, that's really interesting, right? Because we want to tick the box. We want to know we must do this, tick, we must do this, tick. But I think, let me just check who said it, Izan, I think you said it best in the chat. You said, am I correct in understanding that what we have to demonstrate is that we have taken reasonable measures to protect our clients' data and the data of individuals and organizations we work with? So we have to prove that we have tried to keep it secure. We're aware of who has access to what at what time, and that we have implemented a level of due diligence that is defendable. Without, and that's a very different approach to just going tick, 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 we've done all these things. So
I think the critical word there being defendable, as you've just said it now, I think there's no better way to describe it. As long as you can defend, the measures that you put in place. So that's spot on.
Yeah. So Peter, just because the questions are coming in here, Peter's asked, Apandile, what happens? Can anyone be the information officer as a start? And do you have any insights as to what happens if we aren't registered with the regulator?
So practically, I'll start with the registration itself. So there's two ways to register an information officer in terms of the legislation. There's an online platform that you'll find if you go to the information regulator's website. And there's also a way that you can complete a form physically and email it to them. But they do encourage you to use the portal. But the portal has been down for quite a while. Sometime towards at the end of June, you could easily register your information officer and your deputy information officer with no hassles. It would literally take you 3 minutes. But in the past 3 weeks, it has not been possible to do so. And if I remember correctly, there was a guidance note that was issued that there aren't really consequences yet. So they haven't really put anybody, on terms to say you need to register your information officer by the state. If you fail to do so, you will be penalized, especially because, like I said, the portal is actually not working at this moment. Now, in terms of who can be an information officer in an organization, an information officer in terms of the legislation, basically in terms of a private company, is usually the head of the private organization, but that position can be delegated to a person appointed by that head of the organization. Obviously, there are certain requirements that the delegation is to meet, and those are in terms of the regulations issued in terms of the legislation. And one can also look at the guidance note that was issued sometime in April. In fact, there was one on the 1st of April that was issued dealing with the appointment of information officers and deputy information officers.
If I may ask, if I might just add to that, I think that who do you choose to be information officer? I think by default it tends to be the CEO of the company or the head of the company, unless given to someone else. And I think that if given to someone else, I would suggest giving it to someone that has got a firm understanding of how the processing of data and what technologies you have in your company. It's someone that needs to have an understanding of the inner working of the company, because it's a serious matter and it's a complicated matter if you don't do it right. So have someone in a responsible manner be your officer.
In fact, the guidance note. Apologies, I was just saying, in fact, the guidance note of the 1st of April says exactly that, TM, so thank you.
Perfect. Right, so the very last question we're going to do is, and I think Sibusiso, this is a fair question. If there has been a breach and it's proven that the organization has enforced reasonable measures to train and keep data safe, what happens if the breach was due to negligence from an employee or a service provider? Will the company still be punished as the responsible party? I don't know, Apandile, what are your thoughts on this? I mean, do we know yet, right?
Well, I think, like we said at the beginning of the presentation, it's a principle-based legislation, right? So the principle is that you are a responsible party, which means anything that happens to the data that you process, whether the breach is, because of your employee or the breach is because of a third party, ultimately you are responsible. But there are certain things that you can do. And these things have to be defendable if the information regulator comes knocking. For instance, you need to show the information regulator that you trained your staff. You conduct regular trainings for your staff, and you've got policies in place, and these have been socialized throughout the organization. And if you've got a third party processing your information, you can't assess all systems that your third parties are using. So if you've got, for instance, what's called an operator agreement, which sets out what needs to be in place in order to protect that data that your third parties are processing, I think it will be very difficult for the information regulator to issue a fine if you've taken all reasonable steps, which is training your staff, putting in place the right policies, regularly verifying that people do in fact know what to do to protect information, and you've got that operator agreement in place with the right data protection terms.
I think that's super. Super Caesar says thank you, and I think thank you from all of us. And I think on that note, let's close. We're 28 minutes past 7. I just want to thank everyone on the call. A big thank you to Tian and Apandile for being so engaged, for being willing to come on here. This is a completely pro bono use of their time, and I think we can really thank you as a community. And if there's anyone on this call that feels that they could contribute further to either this topic or to any other topic that could be relevant to the tech and innovation ecosystem, please contact us on engage@siliconcape.com. We love to connect with those who are willing to share their knowledge and learning to the benefit of everyone else who's operating within this ecosystem, or or just interested, and the information applies to them too. Some of the call outs we had to everyone was, please join the Stellenbosch Network. It's amazing. You can find them easily at community@stellenboschnetwork.co.za. As Wusi asked all of us, please, if you have not gotten involved in registering on the Startup Act for South Africa, we'd love to hear from you. For everyone else, please carry on sharing your LinkedIn profiles. I'm going to give Vusi an opportunity to give his thoughts on the session. No, he says thumbs up. He's sorted. Hopefully he learned as much as we all did tonight. Right. And then to everybody who's been here tonight, we really appreciate you being engaged. We try to host webinars as often as we can. Please follow Silicon Cape on our social channels, and anyone looking to partner or become a member of Silicon Cape, please do reach out. Have a fantastic evening, everyone. Tian, Vusi, Apandila, Hanley, and Dylan and Amara at the Loudhailer team, thank you, and have a super good night. Stay safe and healthy, everyone.
Cheers, everyone. Cheers.
Bye-bye.
Cheers, everyone. Thank you.